Hi, welcome to the first episode of the CCMS podcast. My name is Kanda and I will be your host. Before we move any further along, I'd like to introduce myself. My name is Leah Kanda. I'm a licensed quantity surveyor and a certified contracts manager with over a decade of experience in the construction industry, 7 of which have been specific to contract management and dispute advisory for building and infrastructure projects. I have worked mostly in Africa, and I started this platform as a means of sharing the knowledge I have gained over the years on projects and on matters related to contract management. I hope you will enjoy the topics that we will be sharing down the line. And in case you have any topics that you would like me to cover or any other item that you would like me to discuss, mostly related to construction, contract management, and disputes, then please feel free to email me on query@ccms.com. Yes, I created this podcast for a number of people. Number one, if you're a student or if you're any other person that is keen on learning or understanding more about construction contracts, then this platform will try to break down as many things as possible into easily understandable language and in ways that devoid of any complexities. And then second of all, it's also targeted towards contractors to give them a basic understanding of their rights and obligations on a project, or once they've received a contract, what do they need to look out for, and if they encounter any challenge, then what is the way forward. My other target audience is obviously the employer, because they are the other part of any construction contract, for them to understand what are the objectives, what are the risks, and how they should address certain challenges that are commonly experienced on a construction project. The other, of course, is my peers, that is consultants or any construction professional that is involved in contract management at all the different stages of a construction project life cycle, that is from inception to project handover and defects period. The other target audience is any financing institutions, developers, and people in the governmental and non-governmental organization who are trying to get a better understanding of what forms of procurement to use, what construction contracts to use, what challenges and what are the benefits or risks of either. We will really be covering a lot of topics in this podcast, and this is just an introduction. As we go along, the content will obviously evolve also to accommodate the feedback that I will be receiving. But as a starter, that is the primary objective of this podcast, to discuss construction contracts at different stages of the project life cycle. And before we move any further, I want to make a very important disclaimer, and this is that the information that is being shared or that will be shared in this podcast or in any of the websites is not to be used as legal advice. It's purely for informational purposes. It should not be construed as legal advice. Without any further ado, I'd like us to talk about what constitutes a construction contract. And even before that, we have to understand what really is a contract before we can talk about the fundamental aspects of the construction contract itself. I feel like it's impossible for you to talk about contract management without first understanding what a contract is. A contract is a legally binding agreement between two or more parties that sets out the terms and conditions of their relationship. Notice the word legally binding, because you cannot have a contract that is not legally binding. A contract is a legally binding agreement between two or more parties that sets out the terms and conditions of their relationships. It establishes the rights and obligations of each party and outlines the specific actions they have agreed to take or refrain from taking. That's very critical. For a contract to be considered valid and enforceable, it must include an offer, an acceptance, and a consideration. A consideration is basically something of value that is exchanged between parties. In the context of the current world or the modern world, it is a consideration is usually a sum of money. One side, a contract serves as a written record of the parties' agreement and can be used as evidence in a court of law if necessary. If a contract is breached, there will be legal consequence or implication on the breaching party. Remember at the top we talked about a contract outlining the specific actions that the parties have agreed to take or refrain from taking. If any of those parties breaches those specific requirements, then there is a consequence or an implication on the breaching party, which could be the payment of damages, or it could be being compelled to perform the obligations that are unperformed. Contract may be oral or written. There are some oral contracts and there are some written contracts, but in general practice, and obviously we are talking about construction contracts here, is that written contracts are more acceptable. Now that we've talked about what a contract is, then we have to talk about what is a construction contract. And just as the definition has said, it is a legally binding agreement between two parties. Then a construction contract is a legally binding agreement between the employer, who is the owner of the project. The employer could be a developer, it could be a bank, it could be an individual owner. The person who owns the project is basically the employer, and that agreement is between the employer and the contractor being the party responsible for the execution of the construction project, which is now the basis of what the construction contract is about. The construction contract defines the rights and obligations of the parties towards each other. There would be the obligations of the employer and the obligations of the contractor, and also there will be a definition of the specific performance, which is the execution of the works. And in that execution of the works, there will be basically a lot of details which we will talk about later. The specific requirements are outlined either in the drawings or the specifications, and then the consideration would be now the contract sum or the value of money that has been agreed between the employer and the contractor for purposes of implementation of the construction works. We talked about the core aspects of what constitutes a valid contract. We said for a contract to be valid, there has to be an offer and an acceptance. There has to be a consideration, which is something of value. And there has to be a lot of other things that must be fulfilled legally for a contract to be considered a valid contract. Let's go straight into that. The first one is the offer and the acceptance. Basically, a valid contract has to involve one party offering or providing something and an acceptance of that offer by the other party. Party A has to give an offer to party B, and party B has to accept that offer. There has to exist an offer and an acceptance. Second of all, there has to be consideration, which, as I said, is something of value that is being exchanged between the parties. This can be goods, it can be services, it can be money, etc. It has to be something of value, exchanging hands, moving from the example of party A to party B. If party A is offering X or is offering a certain service to party B, then party B has to pay or give consideration in exchange for that item or thing that party A is offering to provide or give. And then there has to be mutual agreement and consent between the parties. As I said, a contract is an agreement. So where there is no mutual agreement and consent, then there's really no contract, because the parties have to agree between themselves. They must consent to the contract for a contract to be considered a valid contract. And that consent has to be given freely and willingly without any undue influence, duress, or coercion. You can check what the differences are in between undue influence, duress, or coercion, but basically the core aspect of what we are trying to discuss right now is that the parties must willingly and mutually enter or consent to enter into the agreement. You cannot force somebody to enter into an agreement. You should not coerce somebody into entering an agreement, and you must not use any undue influence. The fourth is capacity. Capacity in this context is the legal capacity of either of the parties to enter into a contract. This will depend on the jurisdiction, but legal capacity in across board means the parties must be able to, and like they must have the legal capacity to enter into a contract, e.g., the person must be of legal age depending on the jurisdiction. In some countries, for instance, it's under the age of 16, some countries it's 18. For someone to be considered of legal age, they must meet the age threshold that is defined in the jurisdictions covered by the country, or the jurisdictions governing the contract that is being entered into by the parties. Again, the parties in terms of capacity should also be in the right mental state or in the right mental capacity, meaning somebody who is not mentally okay or physically okay is not in a capacity to enter into a contract. And then the person must not be under any influence, that is in terms of drugs or alcohol or any other substance that influences the judgment or capacity of a person to function normally. And last, in terms of capacity, is they should not be bankrupt. As you all know, bankrupt persons do not have legal capacity to enter into a contract. And then the fifth aspect of that constitutes a valid contract is a contract should be legal. So the contract must be for a legal purpose, and it must not involve illegal activities or actions that are against public policy. For instance, you cannot enter into a contract for example, to perform terrorism or to perform acts of fraud or corruption, or to traffic humans or to traffic items that are considered illegal in terms of the jurisdictions that you are operating in. For a contract to be considered valid, then it must fulfill the legal requirements, or it must meet the minimum legal requirements expected. And then the last one is a valid contract must also meet the formalities and conditions precedent. Meaning, for example, in a construction contract, if it says you must produce a performance guarantee within, or you must sign the acceptance within 10 days of receipt, then you must fulfill those formalities. Otherwise, then the contract becomes void. I think those are the 5 or 6 main aspects of a valid contract. To recap, the first be an offer and an acceptance. The second one is there must be a form of consideration. The third one is there must be mutual agreement and consent between the parties who are entering into the contract. The fourth one is that the parties must have capacity. Again, capacity in this context is they must have the legal capacity to enter into a contract. The fifth one is the contract must involve legal activities. Again, I will specify you cannot have a contract for illegal activities. And then the sixth and most important, especially for construction contracts, is you must meet all the formalities and the conditions precedent. Now that we've talked about what constitutes a valid contract, we have to talk about what then would render or make a contract voidable. We talked about what constitutes a valid contract, and in this second part, we will talk about what are the things that can make a contract that was once valid invalid. The process of making a contract that was once a valid contract. That means when we talk about a valid contract, we're talking about a contract that initially had met all the 6 or so points that we previously mentioned, and there are certain things that may occur and can render that contract void. That's the process of making it voidable. Voidable means an occurrence. Voidable means that a contract that was once valid then is rendered void. The first aspect is if there exists or there existed a misrepresentation. And in the first part, we talked about what constitutes a valid contract. And in this second part, we will discuss about what are the factors that would make a once valid contract void. That process is called voiding a contract, or the process by which a contract that was once valid is rendered void. There are certain factors that could render a once valid contract as void or voidable, and the first one is misrepresentation. Misrepresentation is whereby one party makes a false statement or gives a false illusion or misrepresents a material fact to induce the other party into entering the contract. Misrepresentation. So misrepresentation is whereby one party makes a false statement or misrepresents a material fact to induce the other party to enter into the contract. The first factor that would render a contract voidable is misrepresentation. Misrepresentation is whereby one party makes a false statement or embellishes a material fact with the intention of inducing the other party into entering into the contract. This is basically where you dupe somebody into entering into the contract on the case of false pretense, if this were human beings. But in the context of a contract, it's whereby you misrepresent the reality or you give a false impression of what is the actual situation, and that the other party relies on that false information or statements that you've presented them into. They rely on that information and they enter into this contract. And later on, they come to find out that you actually embellished the facts. That's what constitutes misrepresentation. The second one is duress. Duress is whereby one party uses physical or emotional pressure to force the other person to enter into a contract. In this context, as we said, a contract must be a subject of mutual consent between the parties. If one party is using their undue influence to either threaten or force another person into entering a contract, then that process or that use of force or duress may or can make a contract voidable. The other one is the use of undue influence, where one party uses their position of power or trust to induce the other party to enter into a contract. You can see a lot of this, for example, in some government projects whereby the one party has more power compared to the other party, and they use that influence to induce the other party into entering into a contract. Don't get me wrong, parties that have different levels of power or influence can enter into a contract, but the problem or the aspect that would render a contract voidable is whereby the party that has the higher power uses that power and authority to influence or force the other party into entering into a contract, either by virtue of them having more information or more power or more decision-making points, etc. The issue here is where the use of that influence to induce the other party. This is a grave mistake or a mistake of a material nature, then that can render a contract voidable. These are mistakes, for example, such as gross mistakes in the value or the price or the terms and conditions that are involved in the contract. It has to be a material mistake, not just any type of mistake. It has to be a grave mistake that has a huge impact and influence in the contract. The other one is if either party is incapacitated. As we mentioned earlier, for a party or for a contract to be valid, both parties must have legal capacity. What happens is if either of the parties becomes incapacitated, for instance, if at one point a party who once had legal capacity now no longer has that capacity, for example, where somebody becomes bankrupt or somebody becomes mentally or physically unable to perform the contract in the process, then it can render the contract voidable. And then the other and last and final is illegality. If the contract becomes or involves something that now becomes illegal or violates public policy or violates the law, then it can render the contract voidable. An example of this point is, for instance, in a lot of countries, the use of asbestos was allowed in the past, but because of its connection with lung cancer, etc., it became illegal in a lot of countries. It was banned. What if you had a contract for the supply and installation of an asbestos roof or ceiling? Then obviously you cannot perform those works because it would no longer be legal. It would now involve an illegality. The parties have to either meet and restructure the contract, or they can render that contract voidable and start over. Then you may be asking yourself, then what is the difference between void and voidable? A void contract is a contract that was non-existent from the get-go. That is, none of the parameters of a valid contract existed. Whereas voidable contracts, or a voidable contract, is the process or the ability or potential of a contract to be declared invalid or unenforceable by one or both parties as a result of a defect in the formation of the contract. This means that although the contract was initially valid and binding, it may become voidable or invalidated due to the certain factors as I previously stated. Those are the factors that make a contract voidable, which is misrepresentation, duress, undue influence, existence of mistakes, incapacity of the parties, or illegalities. And a void contract, as I said, is a contract that was completely invalid and unenforceable from the onset due to a fundamental defect such as illegality or lack of capacity of one or both of the parties. About what voidable and void contracts are, it's key to distinguish between, or to note that a contract does not or is not automatically voidable just because of the existence of either one of the factors. The burden of proof usually lies on the party that is seeking to void the contract. If, for example, there exists a mistake, if the parties are willing to continue with the contract, then they can easily rectify or correct the mistake and agree to continue with the contract. A mistake does not automatically render a contract voidable. It's only if one of the party is seeking to void the contract. The parties have the option of modifying the terms and conditions because, again, contracts are a subject of mutual agreement between the parties. So the parties can always modify the terms of their initial agreement because the agreement rests with them. And that sums up our first episode of the CCMS podcast. We shall be doing a weekly podcast, and our next episode will be next week, where we will talk about construction contracts, and then we will delve into standard forms of contract available in the market, how to select a contract depending on your project, what are the factors to consider. That is the subject of our next episode. I hope you will join us again. Feel free to email me in case you have any topics that you would like me to cover or discuss. My email, or the email that you should use to send your details and queries and comments, etc., is query, That is QUERY, query, at ccmsco.com. Thank you guys. Thank you for tuning in till the very end. And I hope to see you during the next episode. Bye bye.